Well, hello everybody who is waiting for us to start. We're going to be starting in just a minute. Hi, Marty. It's so nice to see you. We're waiting for Sunny to come back in because she was having trouble with her video. I have access to the slides and I am more than happy to share those. Just let me know when you want to change slide and I will move forward. Beautiful. I can see you.
We are. We're all here. Fantastic.
All fixed. We are going to be streaming this to our library Facebook as well, just so that we can kind of hit as many people as we can. For those who are watching this on Zoom, I will put my contact information in the chat. Feel free to email me. I am going to be sending out, if you already have gotten the link for the folder that has all of the slides in it, as I add to it, you should still have access to everything new. I shouldn't have to send you a new link. If you would like the old slides, the recordings, and the chat, I am more than happy to send you a OneDrive folder link that you have access to all of that in perpetuity. So with that, if everybody is ready, I'm going to share this on Facebook and then we can get started. Alrighty, it should say we're live streaming. Beautiful. Hello, everybody. My name is Jennifer, and I am a librarian at the New Haven Free Public Library. I manage our I've Squared section, which is part makerspace, part community hub, part entrepreneur help thing. We do a little bit of everything here, but I am super excited to be continuing this series with SCORE and SBA on taking your business global. As I said before we went live on Facebook, I'm going to put my information in the chat. I'll put it in the comments on Facebook as well. For those calling in over the phone, it's jennifer.jgargiulo@nhfpl.org. I'll actually make it my name. Not that that will make a difference to you. So with that being said, if you ever have any questions, please feel free to put them in the chat. We are monitoring that chat at all times and we will pass on your questions. Okay. So let me share my screen, which is all of the slides, and we will get started. Presentation. And start from the beginning. All right. So this is technically session 5. Session 4 had to be postponed because of a death at the library of one of our staff members. So thank you for being understanding of that. That session will be rescheduled for later in the month. This session is an overview of U.S. export controls, economic sanctions, and anti-boycott laws. So we have some phenomenal lawyers in today to do this presentation. We have Matt
and also intellectual property. When we leave Marty out there, that's part 2. So that's part 1 and part 2.
Intellectual property. Copyright law is like one of my favorite things. So with that, I don't know if you would like me to introduce you, but their bios are on the screen. But I think it makes sense for you to introduce yourselves. You know yourselves better than I do.
Sure, I'll happy to start. And I don't plan to read through all this, but just quickly, my name is Matt Lappin, partner with the firm of Porter Wright, based in Washington D.C. My area of expertise is international trade, covering various aspects of it. Mostly what we're going to talk about here today: export controls and sanctions, as well as other international transactional issues. I've been doing that for a little over 20 years now. And with that, I will toss it over to Sunny and let her give an intro for herself. Oh, I think you're muted, Sunny.
Thank you. So hi everyone, my name is Sunny Yang. I'm also a lawyer and a partner at Porter Wright Morrison Astor. I do mostly international business and trade with a focus of US and China. I do generally helping business that are coming in to the US, as well as US business that's trying to expand internationally. And like Matt, I also work on various transactional and trade issues, including the export control and sanctions, tariffs and customs, and general contract issues as well. And with that, I will turn over to my colleague, Marty Miller.
Hello, I'm Marty Miller. I'm also with Porter Wright. I'm in Porter Wright's Cincinnati office. My area of expertise is in intellectual property. I've been practicing law for over 30 years now, focused entirely on intellectual property issues, including patents, trademarks, copyrights, trade secrets, and related areas, not only in the US, but also assisting clients with foreign intellectual property matters.
We can probably move to the next slide. Before we do this, though, I do want to give a quick pitch and plug for the program. I'll send a link out to this actually separately. It's called the Export Legal Assistance Network, ELAN. There's a website for that. It's a partnership that Porter Wright has assisted the U.S. Commerce Department Commercial Service over the years with offering a network of, and kind of helping coordinate, though we are not the only ones participating, of law firms, generally smaller law firms, mid-sized law firms throughout the country to assist new exporters, folks new to market or folks that are new to international business, identifying either local practitioners in your states or maybe even in your cities or regions, to offer kind of initial consults in particular, as well as identifying other resources that you might want to look to, whether it's obviously with the SBA, U.S. Commercial Service, or other U.S. government entities. Something where, again, we'll touch on at the end, where you'll be able to, pick up the phone, send an email either to ourselves or any other folks that are identified in the ELAN network, and they'll be happy to provide you some initial consultation and any questions you have. So I think with that, then maybe we can kick off. We are gonna move fast, so you may see some slides here that we don't go through every single bullet here. Just know that you're going to have access to this presentation afterwards. We want to make sure we hit the high points, most important points, and try and leave a little bit of time at the end for some questions, because we know some of you may have obviously some questions here, but just to be clear, we will, as I was just saying, we will be happy to take your questions separately offline after the presentation. So we're going to start with U.S. export controls and sanctions. Some of you have probably participated in some of these other sessions here, so you may have heard of these terms. Obviously, sanctions in particular, they're in the news. You hear about them. You probably know a little bit about them. I'm going to explain briefly first what those mean. Export controls first. These are laws and regulations that deal with exporting goods, services, software that are restrictions based on technical specifications of the items. So really what you want to be thinking about here is the thing you're sending or selling, exporting, potentially even software, maybe even just technical information, is it subject to some form of restriction or prohibition, depending on who you're sending it to and where it's going? There's two key types of export controls. We're only really going to focus on one for your purposes. Dual use export controls. This is probably more likely to be the things that most folks that, particularly if they're getting started in the exporting space, would be more likely to encounter, because these are things that are commercial, civil items, things that you may just use in anything from industrial use to home use, that also, though, in some cases, can have what's either considered a military or even potentially restricted use. And we'll talk a little bit more about how that works and how that happens. There are also separate defense export controls, which really deal with military items. We're not going to spend a lot of time on that. I may raise it at some point just so you're aware of it. But unless that's the business you're in, unless you're dealing with selling to aerospace companies or other companies that maybe subcontractors to the U.S. government, probably not something you're going to run into. So we're not going to focus on that. Now, I wanted to separate that out from sanctions, which Sunny's going to spend some time talking about at the second part of our presentation, which again, a lot in the news right now related to Russia and elsewhere. And the key difference that we always like to focus on there is that sanctions are more about who you're doing business with. Yes, there may be some aspects of the export control piece where you care about the technical specifications, what your item is, but really we're going to focus on sanctions on who it is you're doing business with, where the items are going, or maybe even what services you're providing. So there is a bit of a difference between those two. And right now, particularly because obviously the Russia issues, sanctions have a big impact and a much bigger footprint for a lot of even small exporters who may have never thought they would have to deal with those issues, again, depending on where they're selling. We can move to the next slide. So these are some of the folks that you should, think about, that you might need to get to know. I'm sure if you participated in some of these other seminars, you've already got introduced to lots of different government agencies with lots of acronyms and alphabetics that you have to memorize. Maybe we're giving you a few more here. Hopefully some of these you never actually have to talk about or know, but a few you will. So first, Department of Commerce, Bureau of Industry and Security, BIS. These are the guys that mostly regulate, primarily responsible for dual use export controls. Again, those export controls, those restrictions that might apply to otherwise commercial items that may also have some other purposes and therefore can be restricted. They're responsible for regulating it, enforcing it, giving policy guidance, and generally responsible for the whole regime. OFAC, U.S. Treasury Department, Office of Foreign Assets Control. Sonny will talk a little bit about them. In terms of sanctions, so again, you may have seen them in the newspaper talking about Russia sanctions. They're the ones that are primarily responsible for sanctions laws. I mentioned military trade, defense articles, defense items. That's the U.S. State Department. DDTC, we're not really going to spend much time talking about them, may raise them at some point, but they're the ones, they have a completely separate system that's much more restrictive and sometimes a bit more challenging to deal with, that is devoted to defense trade export controls. Hopefully you never have to deal with the Department of Justice, but just know that they're out there and they care about these things. It's, again, a way to think about why these are important. These are ultimately national security issues. The reason that the Department of Commerce regulates the dual use export controls, Treasury regulates sanctions, State Department regulates military items, is because ultimately these are national security issues. And the US Department of Justice ultimately is responsible for enforcing those if they rise up to criminal levels. So just something to be aware of, that this is something the US government takes very seriously, and ultimately DOJ, Department of Justice, could be involved. Other government agencies that may be relevant, probably one you should definitely be thinking of, if you've probably seen them come up in other discussions, if you've participated in these sessions, is Customs and Border Protection, CBP. They're the ones that are responsible for both inbound clearing items coming into the country, as well as clearance of exports leaving the country. So thinking about the paperwork that's filled out, some of the coding, some of the export IT systems that you use. I can't recall if you'd come up with the ACE system. These are the systems, and these ultimately are going to be the primary regulators for identifying items coming into the country, identifying items coming out of the country. So when it comes to who you may have to talk to if something gets hung up at a port, if it's inbound or outbound, it's probably going to be CBP, Customs and Border Protection. Again, then noting some other agencies, Defense Department, Energy, ATF, they have their own separate regulations. All of that to say, to summarize this slide, is that there's a lot of different government agencies that could be involved in regulating exports and imports as well. And familiarizing yourself, at least with some of them, is going to be key for successful exports. You can move to the next slide. So, key concepts for US export controls. There's really 4 that we're going to focus on. Probably 3 of them are going to be the most relevant for your purposes. I'll touch on that last one. The big ones are going to be why things are restricted, why you may have an export that may ultimately be either prohibited or at least might require an export license, again, from the Bureau of Industry and Security, BIS, most likely, to actually export that item. There's 3 primary reasons for that. One is what we call list-based requirements, and we'll talk about each of these separately, where an item that you may have that you want to sell overseas may meet particular specified technical capabilities that are on a publicly available list, which we'll talk about, that depending on where you want to ship it to and to whom you may ship it, may require, again, an export license. So that is going to be solely based on that technical capabilities assessment, and then again, does it meet that item on a list? Where is it going? And does that require a license? That's list-based restrictions. There are also end user and end use restrictions. So that may be, again, this is where we'll talk a little bit about due diligence and knowing your customer, making sure you know who you're doing business with overseas, always a very important point, where you may also need to factor in specifically, not just the country you're selling it to or shipping the items, but ultimately to whom you're selling it to. Is there something about either the business or industry or maybe service that they're in? Are they engaged in military use? Are they a military contractor? Are they engaged in, some intelligence or cybersecurity work? Is there something about what that company or buyer does, or are they a government agency or a government entity overseas perhaps, that puts them in a separate category, not just based on that technical capability, not just based on the country in which you're shipping it to, but actually based on who the identity of that party is. And there are both list-based restrictions, so there are separate lists that identify specific end users. These are the entities list, military end user list, so specific lists. We'll touch on these again a little later, that identify particular parties in other countries that have their own unique restrictions. Or is there some general end use? Is it something that could be used or will be used, more importantly, for some sort of military end use? Again, even if your item is otherwise a commercial item that you might otherwise sell to anybody on the street, but if the ultimate intended purpose is for a military end use or other restricted end use, then that item, again, may require an export license. The last two bullets on here, just want to note them, is one, US law is a little unique in this regard, that it's not just items that you sell directly overseas from the US, exported from the US to a country, but also if you are exporting an item from the US to, let's say, Germany, and then that item is going to then be again exported to another country. The US doesn't only just care, BIS and the other regulators there don't just care about that export to Germany. They also care about where that item is ultimately going to go. So that's one form of what we would call a re-export that the US government, again, BIS, cares about. They also care about items that are going to be incorporated into an item that is manufactured overseas. So if anyone here is interested in getting into the components space, even if you're just distributing items that are maybe manufactured by somebody else in the US, but you're then going to sell those components, those parts to someone, again, let's say Germany, and then those items are going to be put into an item that's made in Germany or maybe made in Mexico or maybe made anywhere. And then that item is shipped to another country. The US still may care about the US content that's in that item. So again, that's another way that the US regulates items that are originating in the US, may go through multiple countries, maybe even incorporated into other items, but ultimately are going to be shipped to another country. Those, again, can be potentially export control. Last point I note, deemed exports, again, it's a bit of a strange concept, but that US export controls can even apply, again, if there's controlled technical data. That's going back to those list-based restrictions. So something that has been controlled, an item that might be controlled for technical specification purposes. The technical data about how you maybe make that item, use that item, develop that item, think like R&D. So if you're thinking of making something, maybe even software. Well, if you want to share that information about how to make that item, again, including software, with a non-US citizen in the US, that itself can be considered an export. Now, again, not everything. This doesn't mean that anytime you have a discussion with somebody who's not a US citizen means you have to worry about export controls. But if you've identified that your item, the thing that you want to talk about, is controlled, is on an export controls list, which we're going to talk about, and then you want to talk about some detailed technical information, maybe share some drawings, technical specifications, whatever it may be, you may have to consider whether even that discussion, whether maybe even that sharing that technical information is itself an export. All right, we can move to the next slide. So again, just to go back to the basics though here, what are export controls again? Just to think about it. These are restrictions on items, software, materials, components, and technical information. So any of those that can be restricted either to individual parties, locations, or for particular end uses. Again, we're going to focus on dual use exports here. And then what we're going to be focusing on is what the nature of the restrictions are. So again, there can be multiple reasons for the restrictions. They can be based on military intelligence concerns, it can be based on proliferation of weapons, which again, doesn't seem like things that we would be concerned about as small exporters, but you'd be surprised. We'll talk a little bit about that. Or even for human rights or their foreign policy reasons. Again, think about things like software that has encryption capability or the ability to use for intelligence purposes. So there's a lot of different reasons that things can be controlled under export controls. We're not going to go through all of those. The main thing to consider though here is that again, these are things the US government has determined are important for these purposes. I see there's a hand raised. If there's a quick question, happy to answer it now. Otherwise we can save it to the end. I don't see it. Well, looks like somebody had a hand raised.
It's Sharon. I've asked them to unmute, so they might have the ability to unmute themselves and ask their
Okay.
question.
Okay, that's fine. All right, we can move to the next slide.
I'm so sorry. I didn't have a question. My apologies.
Oh, no problem. That's
Okay,
fine.
I can lower your hand for you.
All right, we can move to the next slide.
Okay.
So what items, again, can be subject to US export controls? This is an important point, I think, particularly for folks new to exporting, because this is something it's not intuitive and it's worth just taking a second to think about. Just kind of repeating a little bit what I just said, but want to make sure it's very clear. One, anything that's exported from the US can be subject to export controls. It doesn't mean everything that is, but if it meets one of those criteria we had talked about just on the other slide, if it's originating from the US, if it's leaving our customs territory, it can be subject to US export controls. Same as I said for if it's originally from the US and then it re-exports through multiple other countries, again, can be subject to US export controls. Foreign produced items, like we just talked about, if it has a minimum certain amount of US content, or if it's subject to what's called the foreign direct product rule, we'll talk about that for a second, also potentially subject to US export control laws. Items can include, as I said, equipment, materials, components, end items, software, even technical data. So just about anything you can think of that you can either physically or electronically move, which is the last bullet point there, can be subject to export controls. Even things in an email, even downloads of software, if they meet those technical criteria, those end user or end use restrictions, if they meet those criteria, then any of those means of moving things across borders, whether physically or electronically, can be subject to US export controls. Can go to the next slide. All right, so now we're going to go into the meat of it here. So first, list-based US export controls. So the good news for everybody, until you actually read it, perhaps, but the good news is the list-based US export controls are based on a publicly available list that is in excruciating detail, provides specific technical specifications for items that are subject to list-based export controls. It's hundreds of pages long, detailed to the level of very knowledgeable engineers, so both good and bad, that you could look at. You can look at the item that you want to export and see, is there a way that I can export this? Fortunately for those of us, I'm not an engineer. I'm just a sanctions and export controls lawyer. There is a keyword searchable function in and again, we can send a link on this afterwards for essentially an index table of contents that you can do an initial search. Now it's not comprehensive because you might not get the right keywords, but it's a keyword searchable list of just about everything that's in that commerce control list, at least to get an initial idea of, is the thing that I want to send potentially subject to US export controls? It's not going to answer that 100%, but it'll give you a really good idea of what's the potential risk. In that commerce control list, we'll use CCL for shorthand. There are groupings, and items are grouped by categories and subcategories. So we'll have, items that are electronic items. They'll have items that are, materials like minerals, chemicals, things like that. They'll have mechanical components. They'll have, computer equipment and software. They're grouped in those sections. And then with each of those, there's what's called an ECCN, two C's in that, export control classification number. That is an alphanumeric designation. You'll see what they look like below, 3A001 is the example used below. And Each of those will correspond with very specific, again, description and technical capabilities of items that are subject to export controls. So what one does is, if you want to determine if you have an ECCN, an item that is controlled under an ECCN, you'd look at that item. You'd look at the descriptions, ideally, hopefully using the keyword search function in the table, and see, does this describe my item? If it does, then you'd look at the specific technical capabilities and see, is my described item, does it meet these technical capabilities? If the answer is yes, then it's likely controlled. And then you go through the process of determining, based on, again, the destination and the end use, and where the specific end user, like we talked about, does that item require a license? So the example we gave here, microwave power amplifiers, this is under a category though that really covers like just about any sort of microcircuits, microelectronics, things that, even off a lot of things that you could buy, online, in an electronics retailer, that if you look at the Commerce Control List, they are covered in Category 3, Subcategory A, and ultimately an ECCN. So again, if you do your word search, you would find these items listed under 3A001. That's an ECCN, and then a specific even paragraph. So this gets very detailed, a paragraph of B8 that gives you an example of a particular kind of microwave power amplifier with all of these specific technical capabilities. So you can see how detailed it is, which again is good, because then you can look at your particular item and see, does it meet any of these or all of these, depending on what the requirement is. If the answer is yes, like I said, then you likely do have an item that's controlled on the Commerce Control List, and then you have to determine license requirements. If not, then export controls are not going to apply based on list-based export controls. So that's really the process that you go through. Again, that's a lot of questions we get, a lot of questions that I get when it comes to export controls, is that initial question of, do we have a controlled item or not? Once you've determined that though, then you go through potentially determining licensing requirements, communicating with the Bureau of Industry and Security, again, Department of Commerce, BIS. But your starting point is always going to be, do I have an item that's potentially subject to list-based export controls? Go to the next slide. Now, as I noted there's a number of different reasons why you could have these controls. We're not going to worry about that too much, because that's really more kind of for US government policy reasons. But ultimately, the purpose of the ECCN determination is whether or not you need an export license. And depending on where you're sending it, again, that can ultimately determine if you need that license. So for the example I provide here, we gave ECCN 3A001B8. We had identified all those specific technical capabilities and said, yep, these microcircuits, these components are subject to this ECCN. So let's say we get a request to ship them to China. Well, the answer there is China is subject to national security controls, and this is all listed in that Commerce Control List. Again, would I suggest you guys try to do that on your own? Maybe not. You might want to consult somebody with a little bit of expertise. You can certainly consult, ourselves. You can also consult, there are experts with the U.S. Commercial Service and Department of Commerce and SBA International that can direct you to those resources to assist you to determine if there's a licensing requirement. There for China, the answer would be yes. But let's say you got a request from Turkey, or maybe from Germany or from Japan. The answer there would be no license requirement, again, because it's based on US foreign policy. So that's why you have to think of it as this is a commercial sale, but because of the technical capabilities and potential, what they consider security risk of sending these items, there may be licensing requirements depending on the country that you're going to send it to. And that's really how list-based export controls work. You can move to the next slide. A couple of other quick hits on end user and end use restrictions, which we talked about briefly already. So there may be other reasons why things are restricted. First, list-based end user and end use restrictions, different kind of lists. These are lists of specific parties, named parties, again, publicly available, and there's a way to search these. That you can check to see, this is all about knowing your customer. Is who you're doing business with allowed to receive any items from the US that are subject to US export controls, even if they are not otherwise on that Commerce Control List? So even if you have items that are what typically is called EAR 99, which means generally no restrictions. If they're on this one of these lists, U.S. entity list or unverified list, they're slightly different, but they provide similar information. You may not be able to ship any item to them, depending again on the specifics. U.S. entity list and unverified lists are a little different. But the idea there again is the specific end user, the person that's or the party that's going to be receiving them may be restricted or prohibited, even if the item themselves don't show up on those list-based restrictions. So that's one piece. The other ones here we note specific to military, which again, probably less likely that you're necessarily going to be dealing with an end user somewhere overseas that's military or military intelligence related, but just be aware there are also specific restrictions on those. Again, specific either military uses, or if you know the party itself is somehow an arm or actually body of a military end user, particularly in countries, again, we noted China, Venezuela, Myanmar, probably countries that you're not likely to be doing business with, Russia, another one. But in case, again, you have any questions, if you note that your potential end user or customer seems to have some sort of military affiliation, something to check out before you send it. We also note that the U.S. does have an appeals process to challenge or request these sort of listing processes, but that's not something that, you know, in case your end user or customer asks you about, that's not your job. That's something that they could deal with. Ultimately, you should be concerned about knowing who your customer is, and if they appear to be on any of these lists or fit one of these descriptions, you may want to reconsider that export, or at least look into you know, careful due diligence before you decide to export. All right, next slide. Okay, a couple more things here we just want to touch on. Re-exports, we already talked about. Again, the idea that once an item is originating from the US, if it goes to a third country, a fourth country, a fifth country, it can go around the world, but it is always subject to US export control laws. So again, that example we had of the microwave power amplifier, again, microcircuits, it can go to a trading company in Canada, no problem. We love Canada, great, no export controls or license restrictions. Then it can go maybe to their warehouse for a while, goes to Turkey after that, still no export license required. But then later on, if it's going to go to China, an export license would be required. Now, is that your responsibility as an initial exporter if you don't know anything about those transactions? No, that's not your responsibility. But if in your initial deal that you're looking to make, somebody says to you, yeah, it's going to Canada, and then it's going to go to Turkey, and then it's going to go to China. So if you're aware of where it's ultimately going to be routed and end user, then this is your responsibility. Again, just as we had talked about, if we know the end user is in China, it's going to be a license required for this item. So just think about once something leaves the US, that export, US law follows it everywhere it goes. Next slide. Okay, we're not going to get into all the details on this. This gets complicated. So these are the two, what we call the foreign produced US export control application, but I just wanted to give you a heads up on these. So de minimis US content export controls, what you need to know there is that if you find that your component is actually on one of those, has an ECCN that is attached to it. So again, you've gone through that list-based review. You know that applies. And then you also know that it's getting incorporated into some other item down the road, you know, that's going to be manufactured overseas. Just know, and really this is really more for the overseas manufacturer or really for the end customer that you may be dealing with, just know that that end item that your component is getting incorporated into could potentially require an export license, just like as if it had gone straight from the US. Again, not something that you would likely have to deal with yourself, but be aware, particularly again, when you're looking into who you're going to do business with and ultimately understanding what the potential list-based export controls that you may have to deal with. Just know that if you are looking into, you know, dealing in components, particularly electronics, this usually comes up in, that this may be an issue that you have to negotiate either with your overseas distributor or overseas manufacturer you may be working with, or even ultimately the overseas customer. Can go to the next slide. And just to throw one more example of this in the mix, another final piece of what we would call the extraterritorial application of US law, meaning US law that still matters outside of the US, foreign direct product of US content. So this isn't where you have some, percentage of US content, some electronic component that's going into a foreign manufactured good. This is where a foreign manufactured item is being based on either technology or maybe even design information, or maybe even based on some industrial equipment that was used to make it that is of US origin. So again, similar concept in that it's unlikely you are going to have to be the one who is on the hook for this, but if you are intending to get involved in a transaction that involves some sort of overseas manufacturing, incorporation of US items, or if you're going to be sharing potential, some great new idea you have for, particularly something in the tech space that you want to share with an overseas manufacturer, just know, again, that could subject that final item that gets made, whether it's in Germany, China, wherever else, could subject that final item that's produced from your know-how in particular, because you're from the US, to US export controls. So again, it's a little different than the de minimis idea, but same basic idea. You're giving something to a non-US producer, manufacturer, developer, who's going to take that and then sell something again to a third country that may still be subject to US export controls. Go to the next slide. Okay, I think maybe last point on export controls, but just wanted to flag it again. I mentioned in the beginning, deemed exports. These are, again, the concept of sharing information, and that can be verbally, it can be electronically, it can be hard copy, with, again, what are considered non-US persons under the law. It means anyone who is not a green card holder or a US citizen or has asylee status, so anybody other than that. If you want to share that information with somebody, even in the US, and that information that we're talking about, again, electronic, physical, verbal, however it may be transmitted, is controlled. So again, it's not anything. You can have lots of conversations that have no bearing on this. But if the technical information is about an item, a software, material component that itself is controlled, you should be considering whether the information you want to share about that item may also be controlled. And therefore, that discussion, that transfer that happens in the US may also be subject to US export controls, and therefore could also require a license depending on the citizenship or nationality of the person that you want to share it with. Whoop, I think we're going the wrong way. And I think we can go to the next slide. I think that is my piece. So I'm going to hand it over to Sunny and let her run with it. Uh-oh, did we lose Sunny?
Yeah, I'm still here.
Oh, you're there. There you are. Okay, good. There you are. So that is my quick spin through US export controls. I'm going to hand it off to Sunny for some discussion about sanctions.
Thank you so much, Matt. So now I'm going to turn over and talk a little bit about US sanctions. While in the news, we also heard US export control and sanctions together because the concept often get mixed together, but we're actually talking about two separate laws and rules. Sanctions, we cover a range of transactions. We're not just talking about export. We're talking about import. We're talking about financial transactions. We're talking about service agreement. We're talking about licensing like that. So anything that can apply in terms of sanctions. And we are not going, the sanctions also is not really based on the technical item, technical specifications or the product, but it's mainly based on who you are dealing with and wherever the other transactional party is located. So US laws apply jurisdictional of sanctions to any US persons, wherever you are located, both in terms of corporate entities as well as individuals. So for example, if you are a US corporation, that sanctions law applies to you wherever you are located. And also if you are a US citizen, also a US green card holder, the sanctions law applies to you wherever you are located. Even if you are not within the US, you have to comply with the sanctions rules. And in addition, the US sanctions law applies to any person that's located in the US, whether or not you are a US citizens or green card holders. This includes any foreign companies with subsidiaries in the US on a corporate perspective. It also applies to US, any person in the US on different types of visas, like work visa, business visas. If you are physically in the US, regardless of your citizenship status, you are subject to, and also you have to comply with the US sanctions law. Sanctions applies to any transactions involving any goods or services of US origin. So if you have any products that's of US origin, and that being shipped overseas, and then again, it's being re-exported, the sanctions law applies to that re-export, and it can apply to any US dollar-dominated transaction as well. So if you have a contract, somehow this contract has no relationship to the US, but the dollar amount you use is US dollars, right? So you use the US dollar trying to clear that transaction. Even if you have like a French company dealing with a Iran company, for example, if you have a US dollar in a transaction, that transaction is still subject to the US sanctions. So as you can see, the US sanctions applies extremely broad, and just understanding that is very helpful. So now we're going to take a look at an SDN list that's called US specifically designated nationals, and we typically call that as SDN. OFAC, which is Matt explained earlier, the Office of Foreign Asset Control under the Treasury, they publish this SDN list where they list those individuals as well as corporations that been listed in that list, which means that you can't really have a transaction with those people, even if you are subject to the sanctions jurisdictions. Those people will be put on the SDN list either by executive orders or by the Treasury regulations. Although practically, we may often see individuals or corporations being put on the SDN list based on the presidential executive order before the formal OFAC regulation is issued, and they've been put on that based on that. One difference between the SDN list compared with the entities list or the military end user and use list or the unverified list Matt talked about when we're talking about the export control list is that those export control lists only applies to those corporations and individuals listed on those lists. It does not apply to those affiliates, but the SDN list that applies more broadly. So it not only applies to any entities that are being listed on the SDN list, it also have this 50% rules. So that means any entity that owned more than 50% by an SDN is also considered as an SDN. So you cannot have any transaction with them. This means you probably have to do more due diligence if you're engaging in a transactions like this. That's likely there might be some sanctions issues. You have to look at affiliates just to understand whether this 50% rule that would apply. So if someone is being put on the like SDN, so they are. This means this is complete blocking sanctions. So all assets are considered being blocked by financial institutions, and no transactions are permitted with a party that's being designated as SDN. And normally you can't really get a license to transact with any party being designated as SDN unless it's being specifically noted by OFAC, but it's very challenging to try and get that license. This is different from the export control list because it's much easier trying to get export license with a BLS than trying to get an license from the OFAC if you are trying to deal with an SDN. And typically, if anyone is being put on SDN list, you don't get any wind down period. That means immediately this person is being put on the SDN, you have to stop doing any kind of transaction with those people. Although recently, with Russia sanctions and other issues, OFAC has begun to issue general licenses more frequently with such wind-down period. But as a general matter, we typically don't get any wind-down period for transactions with those SDN parties after they're being listed. So just now we are talking about those sanctions that are based on the SDN list. There are also different type of sanctions that's more geographically based. We call that geographic based sanctions. Right now, it applies to several countries as well as regions, including the Crimea, Luhansk, and Donetsk regions of Ukraine. It also applies to Cuba, Iran, North Korea, and Syria. And some of those sanctions are multilateral sanctions, and some of those sanctions are more unilateral sanctions. Again, this 50% rule also applies. So any party, if they own 50% or more by a party in a sanctioned location or sanctioned country, they are also sanctioned. That means if we have, for example, a Cuba company, they own 50% of another UK company, for example, and you cannot have any transaction with that UK company unless you obtained the license. These geographic sanctions apply very broadly in scope, but often we do get this so-called general license issued by OFAC that permits specific types of transactions. So unlike the SDN list we were talking about, where it's very challenging to get that, if not impossible, it is possible to get this general license to have a transaction with those parties, but you have to get a license before you can do that transaction. So I'll give you some examples. We have a US item that's originated from the US. First, it's being exported to Hong Kong. Now we have a company that wants to re-export that to Crimea. And oops, my battery is running now, sorry. Which, as you know, the Crimea is a sanctioned region, and you cannot have that transaction unless you have a license. Another example, if we have equipment, if we are trying to service this equipment of a pipeline that's operated by a company that's 51%, like 50% or more, owned by an Iran state-owned entity, we cannot do that service of this pipeline unless we get a general license from the OFAC. Next page. Additionally, in addition to this list-based sanctions and geographically based sanctions, we also have the sectorial and targeted sanctions. In terms of those kind of sanctions, right now, it's mostly applicable to Russia. Specifically, it applies to those Arctic offshore and oil shale projects in Russia. It also applies to the Nord Stream 2, the certain pipeline project in Russia, and it applies to multiple Russian banking sectors, especially those Russian state-owned banks. It applies to those military items, military end users, and owned uses items. We also have those sectorial-based sanctions. That's you can have those transactions involving luxury and industrial goods, and there are sectorial limitations based on services, and there are limitations on new investment as well. Other than Russia, like some other countries also have their own sectorial-based sanctions. For example, for Venezuela, right now, transactions involving government of Venezuela and entities that's 50% or more owned by the government, that's subject to sanctions, meaning you cannot have a transaction with them unless you have entities. Similar to Myanmar, so right now, any transactions that involving specific Myanmar government entities and those state-owned entities, they're subject to sanctions. So you cannot have a transaction with those unless you have the license. And Belarus has been put on sanctions similar at the same time with Russia. So transactions involving specific Belarus government entities, and those state-owned entities are subject to the sanctions, and you have to watch out if you are doing any kind of transaction with those parties. Just making sure you're not violating any rules and you can proceed with that transaction without getting a license. So just now we talked about the US sanctions. We're going to spend some time to talk about the US anti-boycott law. Now, this is a different set of rules. So US anti-boycott laws that prohibit any US person, again, we're talking about US companies, US citizens, US green card holders. Those people are prohibited to participate or agree to participate in any boycott that the US government does not recognize. Right now, those set of law is primarily enforced with respect to certain countries that boycott Israel. So US right now does not boycott or put any sanctions on Israel, but there are certain other countries do so. And US law prohibit any US person that by agreement agree to put any restrictions to boycott Israel. That's why we call that US anti-boycott laws. So this is especially important if you plan to export to North Africa, Middle East, or South Asia, particularly Pakistan or Bangladesh, because those countries probably have some kind of sanctions on Israel. So if you are transacting with any parties in those jurisdictions, you should really look into the agreement you are signing, just making sure that it does not contain any such requests or any provisions that require you to put any restrictions on Israel. Okay, my final slides. I'm going to give you some compliance tips when we're talking about the export controls, when we're talking about the sanctions and the anti-boycott law. First, it's very important if you're doing export for you to know the export control classifications, the ECCN number. You need to do the analysis, either contact the manufacturer, either do the analysis yourself, or you may want to do a CCAT analysis and determination. Just make sure you know the ECCN number before you're exporting. You cannot just assume everything is EAR 99, meaning you don't need to get a license, and don't assume your customer broker or any logistic company, they would know the classification of those items, and don't assume they will be responsible for those classification. It is your responsibility as an exporter to know the correct ECCN number. We had many occasions where the exporter did not do the analysis and they came back a couple of years later and trying to do the disclosures and trying to correct the mistakes they make. So it's extremely important for you to know the ECCN number before exporting. You should really do the end user review and ask the questions, who is the end user for this transaction? Is this country you
Did we lose Sunny?
I think she might have frozen there.
Okay.
Why don't I continue while hopefully she can get reconnected?
Okay.
So yeah, right. I think key point there is that you can't assume that logistics customs brokers are involved. That also includes on end user and use restrictions, due diligence. Ultimately, know your customer, know who you're doing business with. If you have any concerns or questions about it, you should ask them. Also, you can again seek assistance from your local SBA office, U.S. Commercial Service, as well as again, feel free to reach out to the Elon network as well to get some tips on how to appropriately vet your potential partners or customers overseas. And that will be another one of the most key aspects of your preparation to export. Again, part of that's also going to be that screening. There is something called this consolidated screening list. You can look it up online. It's publicly available, and it's a tool that the U.S. government has provided that can actually allow you to get the full information. We always recommend getting the full information of your potential business partner overseas. Get their name and address, and you can plug it in there, and it'll tell you, hopefully with some specificity, if they are on any of those lists. Again, those export control lists or that SDN list that Sunny described. And then again, finally, just in general, watch for red flags of evasion or diversion. And this is just common sense business that we know if you're have someone with an entrepreneurial spirit, you're already considering and thinking about commercial concerns and who you might do business with overseas. Same thing applies here. If there's anything that seems not right about the transaction, what it is they're asking for, the types of payment they might be seeking. Maybe they're asking you for, shipping things to a different address than they seem to be located at. The quantity seems odd. Just, again, common sense questions about what it is they're asking for, why they want it, when they want it, where they want it. Anything that sets off your radar alarms, think about it. Go through maybe our, discussion here, look back on it and see, is there anything you need to be concerned about, again, regarding end use, end user, geographic sanctions, anything of that nature. And again, if you think there's a risk, you might want to look for an alternate business partner, or again, contact an attorney, contact an expert in international trade, and see if you can get maybe any additional or better information based on due diligence or otherwise to get more comfortable with your business partner. Oh, good, Sunny, you're back.
Yeah, sorry about that. I'm not sure what happened.
Okay. It's fine. I went through the last couple of bullet points there.
Yep, I hear you were talking.
And that is just last couple of notes on how to reach out to myself or Sunny on these various export-related questions. But I think with that, we might just hand it over to Mr. Miller here, who will tell you everything that we can't tell you about intellectual property protection when you're dealing with overseas business.
Great, thanks, Matt and Sunny. Very interesting, and I think it ties in well with the area that I'm going to discuss, mainly protecting intellectual property in overseas markets. Next slide, please. So, first things to look at is why you should be looking at taking action now. So you may be in a situation where you're looking at going into overseas markets, or perhaps going into new overseas markets. So when it comes to intellectual property, there are a few things to keep in mind. First is that intellectual property rights are territorial in nature, particularly with respect to patents and trademarks. For example, US patents aren't really enforceable in other countries. Unregistered trademarks also are difficult to protect in most other countries, unless you're talking about marks that are famous or well known. And then waiting to take steps to protect your intellectual property rights, especially for patent protection, can result in a loss of rights in most countries. And then also it's wise to determine if there are any kind of risk of infringing third-party intellectual property before you enter, various overseas markets. So first, I think it's good to then look at just kind of get some of the nomenclature down so we know what we're talking about here. So really 4 types of intellectual property. First one are patents. And generally speaking, there are 2 types of patents, utility and design. Utility patents, those are what most people think of when they hear the word patent. So it's protecting the functional aspects or features of an invention. But we also have design patents. Now, design patents protect just the ornamental appearance or design of a product. So what the product looks like. Many industries, those are quite common. One, for example, are shoes, the sole pattern on shoes. There are even many design patents on the dimple patterns on golf balls and golf club patterns, things like that. Patents are a little bit different from other forms of intellectual property in that they do require the timely filing and successful examination of a patent application. And we'll get to that here in a moment. Trademarks, on the other hand, are source identifiers. So these are things that identify the source of goods and services. So these will include words, phrases such as taglines and slogans, logos, and sometimes even things like color or sounds can be protected as trademarks. And generally speaking, trademark protection also includes under it the concept of what's called trade dress. So trade dress would be the overall appearance of a product or product packaging that itself serves as a source identifier. Now with trademarks, registration is not mandatory in every country. For example, in the US, you do have a concept of what are called common law trademark rights, but registration is highly recommended. And in some countries, it is required in order for your trademarks to be protected. Next slide. And then the final two types of intellectual property, and I should say the heading says in the US, but this really applies in just about every other country of the world, and especially in any major markets. So we have copyright. Now, copyright protects works of authorship, including things such as literary works, including photos on websites, audio-visual works such as videos, music, which can include not only the music itself, but the lyrics and even the performance. And then for copyrights, one key distinction is that registration is not required for something to be protected under copyright law. And that is true in just about every country in the world due to what's called the Berne Convention or treaty. In some countries, even registration is not even possible. They don't have a registration system at all. But in others, registration can be beneficial. For example, in the US, if you want to sue someone for copyright infringement, you have to have a copyright registration prior to bringing suit. Now, that doesn't mean you have to go out and register your copyrights by a certain deadline. But what that does mean is if someone's infringing your copyright, you are going to have to take that step of registering your copyright before you can bring suit. And then in other countries, such as China, registration can be very valuable in that it acts as evidence of your ownership of the copyright and also enables you to use some other avenues to protect your copyrights in China and even to prevent infringement. And then finally, trade secret protection usually is, most people consider it as falling under a type of intellectual property. And that is just information that's not generally known to others, particularly your competitors, and cannot be reverse engineered and has some sort of economic value and is subject of at least reasonable efforts to preserve its secrecy. Now, there's no registration for trade secrets, but you do need to take active steps to preserve that secrecy, and things such as securing files, limiting access to facilities, limiting access to file materials based on a need to know, and then confidentiality agreements with third parties, such as manufacturers or distributors in some of those new markets you might be going into. Next slide, please. And I see there's a question about if there are online resources and software apps that help with policing. I assume that means intellectual property. There's one, for example, Simple One or Google Images, where you can search for others that might be using your photographs without permission. And there are other monitoring services that you can engage with to monitor for online infringement and the like. So going back to the slide then, I'm going to look first at patents and just the basics here. So what does a patent do? It gives the owner the right to prevent others from making, using, selling, and importing the patented invention or design. Now, one key thing to keep in mind here, though, is that a patent does not give the owner the right to practice the invention. And the way to think about that is that you can obtain a patent on an improvement to someone else's product, for example. And that other product might still be under patent. So you can get a patent to that improvement, but you may not, at least for a certain period of time, have the right to practice your own patented invention. So for patentability, generally there's two tests that are involved there. One, that the invention or design has to be new or novel. And then secondly, it has to be non-obvious over what's called the prior art. So the prior art for patents is everything, essentially everything that came before, everything that was part of the common knowledge anywhere in the world at essentially any time will qualify as the prior art. Now the standard, particularly for non-obviousness, is going to vary from country to country, especially for design patents. So in the US, for example, it's a somewhat more rigorous standard, whereas in many other countries, it's not. So it's very simple to get design patents or design registrations granted. Next slide, please. So first, we're looking at utility patents, and as I said before, these protect the functional or useful aspects of an invention, can include processes and methods. In the US, can even include methods for treating medical conditions. In fact, many pharmaceutical patents are based on that very thing, because you often have drugs, for example, that may have been known for decades, yet someone discovers that there's a new treatment that drug can be used for. And so things like that can be patented in the US and many other countries. Duration of a patent is 20 years from the earliest filing date, although there's some provisions to extend that duration, for example, if there are regulatory approval delays for pharmaceuticals. Next slide, please. Now in many countries, we also have utility models. And I call this 1A because they are kind of a little bit different than utility patents. So utility models are less expensive to obtain, have a shorter duration than your typical utility patent, less stringent examination. Some countries there's no examination at all. And typically there's a reduced inventive standard. So they were created originally to give protection to, let's say, small improvements in existing products or other items. But they've grown to be used very widely in countries where they're available. And these can be valuable tools for you, particularly because they're, as I said, they're much less expensive to obtain, typically much easier to obtain. And so they're not provided for in the US, but there are other pretty significant markets where you can obtain those, including China, France, Germany, Japan, South Korea, and Taiwan. And I give the example here of China that in 2021, they granted almost 700,000 utility patents, which seems like quite a lot until you realize that they granted over 3 million utility models. So this is a very significant tool that you can use to try to get some protection for your advancements, inventions, and products before entering into some of these markets where they're available. Now, one caveat though is that they're often available only for limited subject matter. So for example, processes and chemical compositions really aren't amenable to utility model protection. Next slide, please. And finally, design patents, as I said, protect the ornamental design of a product. So it's the product's appearance rather than its function that's protected. These are generally fairly easy and much less expensive to obtain. Typically, for example, in the US, the most significant cost is having the detailed drawings prepared by a draftsperson. And there's little or no substantive examination in most countries. Now, the term tends to be shorter in the US. That's 15 years from the date of issuance, 10 years in China. But in Europe, you can have up to 25 years of design protection as long as you pay the renewal fees for those registrations. They do tend to provide very narrow protection, meaning as long as a competitor's product looks different in some meaningful way, they're probably not going to be found to infringe your design patent or design registration, but they do provide some protection that may not otherwise be available at a relatively low cost. So when we look at patent filing strategies, the key thing to remember for patents is that you really need to plan ahead. So timely filing is critical for a couple reasons. First, that patents are awarded to the first inventor to file a patent application. Secondly, while the US has a 12-month grace period to file a patent application, most other countries do not. So what that means is that you have to file a patent application before you make any kind of public disclosure of the invention. That is before you sell the product in question or disclose the nature of your invention to others. So a non-confidential disclosure anywhere in the world can really doom patent protection in most countries outside the US, Canada, and a few others. Next slide, please. Now, there are mechanisms that can assist here. A US patent application can provide priority for foreign applications filed within 12 months of your US filing date or 6 months for designs. And I give the example here that if you file a US application July 1st of this year, as long as you file foreign patent applications by July 1st, 2023, they're treated as if they were filed July 1st of this year. You can also use U.S. provisional patent applications for making that priority claim. The one caveat there is that you want to make sure that provisional application is as complete as possible. Next slide, please. The Patent Cooperation Treaty, or PCT, also can help to defer costs. Effectively acts as a patent application in every member country, which really includes all of the major countries in the world other than Taiwan. And what that does is it allows you to defer that significant expense of filing your application in every country where you want patent protection. So as I note here, you can defer those expenses for 30 or even up to 31 months in some countries. And that can be a big benefit because you don't have to incur that expense right away. And so you're looking at 2.5 years down the line, where by that point you might have a better idea of whether or not your invention is going to be something commercially valuable, and also even where it might have applicability. Next page. You can also use regional patents to streamline the examination process and save money. So I gave the 4 examples here of those regional patents that are available. European patent protection is quite commonly used by our client. And as you can see, it covers 38 plus countries, including all EU members and the UK. And the UK is included because the European Patent Office is not technically under the auspices of the EU. Next slide. And so on the question of where to file, we often get this question from clients, and there's really no hard and fast rules. Certainly cost is always going to be a factor, but other things to consider are the major markets where you anticipate doing business, and also countries where you intend to manufacture or where your competitors typically manufacture. So you may view a certain country as not being a big market for your invention, but if you're going to have it made there, it really might help in terms of if suddenly a competitor starts infringing your patent in that same country. And then also keep in mind that you should always consider markets in which you may have licensing opportunities. So you may not be looking at actively going into a particular country or marketplace, but there may be licensing opportunities that you can take advantage of in those countries. Now, if you don't obtain patent protection in that country, there's really no way for you to stop someone else from copying your invention and marketing it in that country. And finally, and this ties along a little bit with Matt, some of what Matt was discussing, for inventions made in the US, you do have to file a patent application either first in the US before you file overseas, or you submit the subject matter to the US Patent and Trademark Office for security review so that they can then grant you a foreign filing license. And the only time you wouldn't get that is if the technology pertains to some particular field that's of concern, such as information warfare related inventions or military related inventions, things of that nature. Next slide. Moving on to trademarks, are there any questions on the patent side of things?
It looks like that we actually have a couple of questions. One is to clarify, U.S. copyright or intellectual property is recognized and protected internationally because of the bank law? Question mark.
Yeah, okay. Yeah, happy to clarify that. So it's not really the U.S. copyright that's being protected. So what happens is whenever for copyright, and this goes for most countries of the world, as soon as something is put into a tangible form, for example, if I draw a doodle on a piece of paper, as soon as I form that doodle on the paper, a copyright exists in that drawing, no matter how good or how bad it might be. And that copyright is recognized and protected in almost every country of the world. And that is because of what's called the Berne Convention, B-E-R-N-E. So that essentially is a treaty that most countries have signed on to, where they've said, yes, we will write our intellectual property laws so that there is copyright protection from the moment something is created. So that's what I was referring to there in copyright.
All right. I think the rest of these are more general and have been answered by other people in the comments already. So
Okay.
we can move on.
So moving on to trademarks. As I said earlier, trademarks are source identifiers. So include a word, a phrase, and a phrase might be a tagline or a slogan, a logo, a design, or any other indicia that serves to identify and distinguish the source of goods or services. Now, sometimes you might hear the word service mark, and all that is referring to is a mark, that's used in connection with services rather than goods. Most people, though, will use the word trademark or even word mark to refer to both trademarks and service marks. Next slide. Now, product configurations, product packaging, colors, sounds, scents, and other things of that nature can also be protected and even registered sometimes as trademarks. And one example is the shape of the Hershey Kisses chocolate. That is a federally registered product configuration trademark in the US, and I'm sure in many, many other countries. Now, the one caveat here is that for product shapes and configurations, you do need to show proof of acquired distinctiveness. And what that means is that you've used that product shape, for example, for a long period of time exclusively, and you've extensively promoted to the point where consumers suddenly recognize that product shape as a source identifier. So if someone sees a chocolate in this shape, they'll immediately recognize that that is chocolate from the Hershey's company. Next slide. Now, two things to keep in mind, because I think it's important from the standpoint of evaluating trademark protection and when there can be trademark infringement. So the purpose of trademark protection is to, number one, prevent consumer confusion. So you don't want someone out there confusing consumers into thinking that this piece of chocolate they're buying is from Hershey's when in fact it really isn't. And then secondly, trademark protection also protects the owner's goodwill and reputation associated with the mark. And what that's referring to is really the value of trademarks to companies. In some instances, companies' trademarks can be the most valuable piece of property that they own. And that might be, for example, restaurant chains. Take, for example, the restaurant chain Cracker Barrel. That their trademark is probably the most valuable piece of, most valuable asset that company owns, over and above, the physical assets that they might have. All the restaurants could be wiped out, but they could then rebuild those restaurants under the Cracker Barrel name, and people are going to recognize their restaurants. Next slide. Now, unlike patents, there's no per se time restriction for trademarks in terms of when you need to register them. Now, having said that, though, filing early is still a good idea. Now, trademark protection in the US does not require registration, but registration requires significant advantages in the US as well. For example, a federally registered mark provides protection nationwide in the US, even in those markets where you might not have entered into yet. On the other hand, there are many countries that do not recognize unregistered marks, for example, France, or they provide very limited protection, especially if the mark is not famous or well known in that country. So in those countries, it really is wise to obtain trademark registration early on, if at all possible. Next slide. Now, outside of the US, proof of use of a mark in commerce is usually not required for registration. And this can be important because it's not uncommon in some countries for a third party to register the trademarks of US companies, many times intentionally, other times unintentionally. So most of those countries do provide for the cancellation of registered marks due to non-use. This usually requires a lengthy period of time, for example, 3 to 5 years. So you can find yourself in a situation where you're suddenly entering a new market, only to find out that a third party has registered your trademark in that country, or registered a trademark that's very similar to yours. And that can cause real problems for you, even if that company has never used that mark in that country. And that comes up quite a bit for many of our clients. Next slide. So one of the things too then to consider is conducting a trademark clearance search before entering a new market to get an idea of, okay, are there third-party trademarks registered in this country that I need to be aware of or that might cause problems for me? Some instances it might cause you to have to change your mark for those particular markets. But it's always best to know what you might be up against. And sometimes you might even be able to find creative ways to deal with third-party registered marks, such as purchasing their rights to the mark or getting their agreement that you can enter that marketplace. It's also a good idea to file applications to register your trademarks in new markets as early as possible, and even prior to doing business in those markets. As I said before, there's generally no use requirement other than in the US to obtain a registration. So it's a good idea to do that and look to see what else is out there. Next slide. Now, a couple final things on trademarks. Like patents, you can claim priority to your US trademark application filing date for foreign trademark applications if you file those applications within 6 months. Now, it's not as critical for patents. It can help prevent problems if you're able to do that where possible. And then there are also regional trademark registration systems that you can use to your advantage, including the European trademark, which in this case does not include the UK because it is under the auspices of the EU. And then Benelux and Aripo and OAPI, and those last two are regional trademark systems in Africa. And they also have, under those same names, regional patent systems. Next slide. Now, in terms of trademark filing strategies, the Madrid protocol is available, and it's somewhat similar to the PCT process that I mentioned previously for patents. So here you can obtain an international trademark registration, but that registration does not confer international trademark rights by itself. So you still have to submit that application in each country where you want registration. But unlike the PCT patenting process, for Madrid protocol registration, you can designate new countries at any time. So what oftentimes happens with our clients is they obtain an international trademark registration under the Madrid protocol. And when they file that, they might designate 2 or 3 countries that they know they're going into or have already gone into where they want to obtain trademark protection. So then 4 or 5 years later, they might be looking at entering some new markets, and they can use that Madrid protocol registration in the same way. So they just add those new country designations and use that international registration to obtain registrations in those new countries. The one caveat is that Madrid protocol filings have to be based on pending application or existing registration in your home country, meaning in most instances here, the US. However, for the first 5 years, that Madrid registration is dependent on your US application registration. So if you lose your US trademark registration, for example, if you abandon it, or let's say someone, third party takes action to cancel that registration, then your Madrid registration is also canceled. Now there's some ways to deal with that problem if it were to happen, but sometimes wise to wait a little bit before you file those Madrid protocol applications.
I have a question that came up in the comments.
Yes.
If I trademark my logo, colors, and other intellectual property related to branding the image of my business, is the federally registered trademark recognized and protected internationally?
That's a great question. Generally, it is not. So, especially in those countries where registration is required. So trademark registrations are territorial in nature. The one caveat there, though, is that if you have a mark that you're using, for example, online, and maybe you're taking orders from other countries, you may have some limited trademark protection in those other countries based not on your US trademark registration, but based on your use of the mark with respect to doing business in those other countries. So for example, if you're targeting some online advertising and sales to Canada, you would likely have some limited trademark protection under Canadian law for an unregistered trademark, but it would not be based at all on your US registrations.
Thank you. That was the only question that came up
Okay.
at that point.
Next slide.
Slide.
And then finally, while I don't want to give copyright short shrift by any means because they are important, just a few points here. As I mentioned before, it protects works of authorship, including literary works, musical works, pictures, and other graphical works, motion pictures, audiovisual works. But copyright does not protect ideas, processes, inventions, or discoveries. So if you have a write-up describing your great new invention, you do have copyright protection in your written description of it. No one can copy your description, but it does not give you any protection over the concepts, inventions that you described in that write-up. Next slide. Copyright's also a very long period of protection, varies somewhat by country. In the US now it's quite lengthy and can stretch out for the life of the author plus 70 years, or 95 years from first publication, or 120 years from creation if it's made by an employee. Next slide. Next slide. And as we talked about before, copyright protection exists the moment a work is fixed in any tangible medium of expression, and that registration is not mandatory, and that some countries don't even allow for that. Next slide. And then monitoring and enforcing your intellectual property rights. A few important things here. One is that you can register your intellectual property rights with customs in most major jurisdictions in the world. In fact, I would say all of the major ones. Now, generally, that's going to require that you have registrations for things such as your trademarks and copyrights. And in the US, though, you can only register federally registered trademarks and copyrights, but not patents. There's proposed legislation to add design patents there. But in most other major countries, you can register trademarks, copyrights, and your designs, either design registrations or design patents. So once you do that registration, customs will monitor for infringing goods entering or leaving that country. And if they find them, they will seize those products at the border. And apart from customs registrations, other monitoring enforcement really is left to you as the intellectual property rights owner. So there are some things, though, you can do to try to prevent infringement and to detect infringement when it's occurring. Some of these are common sense things, though the key, and I think Matt alluded to some of these previously, is be cautious about companies that you're dealing with, particularly ones that do not have an established business. Also important to engage foreign legal counsel to draft or review all of your contracts. There are really pitfalls you can fall into if you don't do that, particularly in places like China, where there's some requirements in contracts that you need to be aware of. And then when it comes to trade secrets and technology, you really need to take steps to limit the access to those things and be creative. Try, look at using things like multiple manufacturers. So each of them is only supplying a portion of the components of your product. And then you might complete final assembly in the US. We have another client that one approach they took, they had a consumer product that relied quite a bit on software in the product to control how the product operated. So they had all their manufacturing done overseas except for the software. So they would have the product in nearly final form shipped to the US, and they would be the ones that loaded the software into the product, because that was the most critical piece of intellectual property they owned. So in that way, they kept that software in their hands only, yet they were still able to take advantage of overseas manufacturing. Next slide. And that's it. And there, my contact information is there. If you have any questions, happy to answer those, or you can reach out to me with the information here with any questions you have later.
I think we legally need to put this up. This is just a disclaimer saying that Porter Wright Morris and Arthur LLP offer these materials for general information purposes only. Obviously, these lawyers have not been retained by you as an individual. Therefore, you should use this information as information and not official legal advice. For legal advice, contact your own attorney or an attorney that specializes in this individually. I think that's pretty easy wrap up of that.
Yeah, and someone has a question about intellectual property of other resources or reference materials. That's a great question. Yeah, there are a number of things out there. The U.S. Patent and Trademark Office has some really good resources on both patents and trademarks. Information on general patent laws in the U.S. Also resources on searching patents if you want to try to evaluate whether or not your new idea or invention you have may be patentable. They also have some information there. And the same thing on trademarks, the ability to do your own trademark searching. For things like that too, I would highly recommend simple things even like Google for evaluating whether or not you have something patentable or whether or not someone else is using a similar trademark. And what I tell clients is that don't use those to reach a final conclusion, but you may find that you are able to find something very quickly, so you might save the expense of a formal patentability search or trademark clearance search. And then I see Jennifer also added a link to the Copyright Office, and they have some really great materials there as well on copyright issues. So I encourage you to look there for any questions and additional information you might need.
Yeah, I also added the U.S. Patent and Trademark Office link.
Yes.
So for those who are calling in, the U.S. Copyright Office is copyright.gov, and the Patent Office is www.uspto.gov, United States Patent and Trademark Office, uspto.gov. At this point, I'm going to open it up for questions. If anybody has any, feel free to either raise your hand or put them in the chat. I am actually looking at the chat now. I'm trying to pay attention to multiple things. Thank you, Matt, for putting in that link for trade.gov, consolidated screening list. People are saying thank you, mostly. This was very in-depth and I appreciate all of the information. Marty, I'm going to be getting in touch with you to potentially do just a copyright thing for
Okay.
business owners. Because while I am very interested in copyright law, I'm not an attorney. So at this point, if there are not any other questions, we are pretty much at time, but we can go over slightly if anybody does have any questions.
Well, John Shu again. Is any question from Selena or Burak? Well, probably particularly Matt or Sunny, you can address, how, as a business owner, how do I, work with, Elaine attorneys? What is the process? Should I call you guys or online? Can you address a little bit on that?
Sure. I mean, just in short, you can, a good place to start is the website link that I'd sent out. You can, contact, certainly myself as the director of the program. And then typically what we do is we'll either, put you in touch with another ELAN attorney in the network who, either may be closer to you or may have some specialization that may be particular to what your question is, or we may address, assist you directly. We offer, again, and all the attorneys that are listed on there, offer an initial free consult to help you with some, kind of your initial basic questions. After that, then, we would obviously, need to have a, formal retainer, but that's usually how we start, is just, an email, a call, to kind of kick it off, and then we can help direct you either to the right local resource, or again, can work with you directly from, my office or one of my colleagues, Sunny or Marty or others.
Thank you, Matt.
And I'm gonna go back into the slides on my end and re-put all of your contact information
Great.
into the chat as well for everybody.
Perfect. All right.
So that's Matt and Sunny, and down to the bottom. for Marty. All right, so that's everybody's contact information. Here is mine. And my direct extension. That's my cell phone number, not my work number. So again, if anyone has any questions as a follow-up, you can contact Sunny or Marty or Matt directly, or you can contact me and I would be happy to put you in touch with people. I will also, again, if you would like for me to send you the recording of this, as well as the chat log and previous recordings, chat logs, and slides, just let me know. And I would be happy to send those over to you so that you guys can reference them later. And if there's no other questions, which I don't think there are, I'm going to say thank you to everyone for joining us. I hope you had a great rest of your day. If you are in New Haven, the library is open until 8 o'clock. Our next session will be next week, same time, same place. Your link will still work. The Zoom link does not change. And then we will have, so that will be technically session 6, but our reschedule of session 4, which was supposed to be last week, will be on the 29th. Also, this link will work for that as well. So with that, thank you very much, everybody. Have a great rest of your day.
Thank you.
All right,
Thanks.
bye, thanks.
Thank you.
Bye-bye.
Thank you. Great.